I was thinking, the last time I went to a doctor, right? I didn't check their diploma on the wall. I didn't ask to see their transcripts from med school. I sat down and trusted them.
It's the invisible engine of the whole professional world, isn't it? Trust.
Exactly. And it's the same with law, maybe even more so. The entire legal system, this massive, complex machine, it all runs on the assumption that when a lawyer cites a case, that case actually exists.
That they use their judgment, that they aren't just making things up.
Yeah.
Because if you have to verify every single thing a lawyer says, the system just grinds to a halt. It's too expensive, too slow, it can't function.
But, and this is why we're here today, that invisible engine is starting to sputter. We're seeing a disruption that goes way beyond, lawyers using spell check.
Oh, way beyond.
We're talking about agentic systems, robots, essentially, that don't just write, but they plan and think.
And that shift is creating what a lot of people are calling a crisis of credibility.
So to navigate this, for this deep dive, we've brought in a really, really heavy-hitting article. It's titled, AI Agents in Law. Transparency is the New Ethics Test. It's by the AI thought leader, Johan Steyn.
Right.
This just dropped in February 2026, so it is hot off the press.
And Steyn is the perfect guide for this, I think. He has that rare ability to look at the nuts and bolts, but then he zooms out and asks, okay, what does this actually do to society, to the idea of truth in a courtroom?
Right. So the mission for today is pretty specific. We really need to unpack why competence, just being a good lawyer, is no longer enough. According to Steyn, we're moving to a whole new metric. And that metric is transparency.
And I know it sounds a bit like corporate buzzword bingo. Transparency.
A little bit, yeah.
But I think by the end of this, you'll agree with him that it's actually a survival mechanism for the legal profession.
Okay, let's get into the tech first, because I think a lot of people hear AI in law, and they still think of, ChatGPT from 3 years ago.
Right, the old stuff.
You ask it a question, it spits out a generic answer. Is that what Steyn is warning us about?
No, and that is the critical distinction here. If you're still thinking about a chatbot that just predicts the next word, you're already behind the curve.
Okay.
Steyn highlights this big shift to agentic systems.
Agentic. It sounds like it has agency, like it's making decisions on its own.
In a simulation sense, it is. Think of the old chatbots like a parrot. You say, hello, it says hello. It mimics.
Right.
An agentic system is more like a travel agent. If you tell a travel agent, book me a trip to Paris, they don't just say, okay.
No, they plan. They look up flights, then hotels.
Exactly. They compare prices, they look at your calendar, they execute a multi-step workflow.
So in a legal context, an AI agent isn't just writing a sentence. It's executing a strategy.
Precisely. It can break a complex legal task into steps. It might say to itself, okay, step 1, find the relevant statutes. Step 2, look for precedents in this jurisdiction. Step 3, draft an argument.
Okay, that makes sense.
But then, and this is the kicker, step 4, critique that argument and refine it.
Wait, so it's playing devil's advocate with itself.
Yes. It's running these recursive loops, so it produces output that looks like it went through a rigorous, multi-hour human thought process.
Wow.
And Steyn points to reporting from TechCrunch, this is from early Feb 2026, showing that these agents are tackling complex legal tasks far more effectively than anything we saw even a year ago.
Okay, I have to play the optimist for a second here. That sounds kind of amazing. If I'm a client and I don't want to pay a junior associate $400 an hour to look up statutes, having a machine that can think through the steps, that sounds like a dream.
It is a dream from an efficiency standpoint. But Steyn argues it becomes a trap. And the trap is in the polish.
The polish? What do you mean?
Because these agents plan and refine and critique, the final product looks incredibly professional. It's formatted perfectly. The language is crisp. It cites statutes with the correct numbering. It looks finished. And because it looks so finished, it completely bypasses our natural skepticism.
I think I see what you mean. If I hand you a napkin with scribbles on it, you're going to double-check my math. You just assume it's a draft.
Right. But if I hand you a beautifully formatted, leather-bound report with perfect footnotes, your brain just defaults to, this is authoritative. You assume I know what I'm talking about.
But the AI doesn't actually know what it's talking about, does it?
And that's the core problem Steyn identifies. AI is probabilistic.
Okay, let's break that down. Probabilistic, so it's It's just playing the odds.
Exactly. It doesn't understand justice or truth or the Constitution. It understands patterns. It just predicts the next most likely word or token in a sequence based on billions of data points.
Yeah.
And Steyn puts it perfectly. Sometimes they are brilliant, but sometimes they are wrong in ways that look right.
Wrong in ways that look right. That is a terrifying phrase if you're a lawyer.
It is the absolute nightmare scenario. Because we aren't talking about a typo. A typo is easy to spot.
Sure.
We're talking about a whole chain of decisions. If the agent decides to prioritize one document over another, or frame an argument a certain way based on a statistical probability, not legal strategy,
Yep.
that's a flaw in the very foundation.
And this isn't just a hypothetical, is it? I mean, we've seen this go spectacularly wrong.
Oh, absolutely. The article references reporting from AP News that highlights exactly this. We are not just seeing bad arguments, we are seeing hallucinations.
I've always found that term kind of funny, hallucinations.
Yeah.
Like the robot is seeing ghosts. But in a courtroom setting, it is not funny.
It's disastrous. Judges are getting briefs where the AI has confidently stated, as established in Smith v. Jones, and then it quotes a paragraph that's legally sound, perfectly written, and
what?
And completely invented.
It made up the case, the whole thing.
It made up the case, the citation number, the quote. It just synthesized them from the patterns of thousands of other real cases.
Can you imagine standing in front of a judge? You filed this brief. You're in your nice suit. And the judge looks over their glasses and says, "Counsel, my clerks have been looking for this case all morning. It doesn't exist."
Your career might not recover from that. It leads to sanctions, to public embarrassment. But Steyn argues the damage goes so much deeper than just one lawyer getting yelled at.
It breaks that chain of trust we started with.
Exactly. Because if a judge now has to wonder if any citation is real, the efficiency of the entire court system just collapses.
Steyn calls this a lack of professional muscle memory.
It's a fascinating way to put it, isn't it?
Yeah, what does he mean by that?
Well, think about how lawyers get trained. You spend years as a junior associate having your work torn apart by a partner. You learn to check every citation. You build this reflex for accuracy. Now we've adopted these tools so fast that the profession hasn't built the muscle memory for verifying machine output. Lawyers are used to checking the work of a tired junior associate who might miss a comma. They are not used to checking the work of a machine that lies with total, absolute confidence.
It's the confidence that kills you. A junior associate might say, I think this is the right case.
Right.
The AI just says, here is the case.
Exactly. And Steyn warns that the real risk is relying on these confident fabrications. If you can't spot the fabrication because the formatting is perfect and the tone is authoritative, you're not practicing law anymore, you're just gambling.
So, okay, we're at a point where we can't put the genie back in the bottle. The tech is here. Clients want the lower cost. Firms want the speed.
Yeah.
Steyn argues the answer isn't just try harder. It's this concept of transparency.
This is the real pivot point of the article. The new ethical test isn't just did you get the right answer, it's can you show how you got there?
Okay, now, when he says transparency, he clarifies this pretty quickly. He doesn't mean I have to print out the Python code for the judge.
Right. No, and that's a really important distinction. Explainability in this context does not mean revealing proprietary model internals or algorithm weights. A lawyer doesn't need to be a computer scientist.
So what does it mean then?
It means being able to answer hard, specific questions when things go wrong. And Steyn provides a list. And honestly, every professional listening to this should probably tape this list to their monitor.
Let's run through them. Okay, scenario. I'm a partner or a judge, and I'm challenging a piece of work. Question 1, what tool was used?
And just saying AI is not an answer. Which model? Was it GPT-4, Claude 3.5, DeepSeek? Because they all have different biases, different training data, different cutoff dates.
Right.
If you used a model from 2023 to research a law passed in 2025, you're just negligent.
Okay, next question. What prompts or instructions were given?
This is huge. Prompt engineering is basically the new giving instructions to a subordinate. Did you tell the AI to write a brief that wins at all costs?
Because if you did, it might hallucinate a case to make you win.
Right. Or did you tell it to summarize the relevant case law accurately and cite all sources?
Those are two very, very different directives.
And if you can't produce the prompt, you can't prove you acted ethically.
Third question. What sources were relied upon?
Did the AI pull from a closed, verified database of case law, like a Westlaw or LexisNexis Sandbox? Or did it just scrape the open internet, Reddit threads and blog posts?
And finally, the big one. What checks were performed and who signed off?
That's the accountability piece. You can't just say, oh, the computer did it. A human, licensed professional has to sign their name to it.
You know, it really reminds me of high school math class. I used to hate this, but the teacher would always say, I don't care if you got the answer 42. If you don't show your work, you get a 0.
That is the perfect analogy. For the last few years, we've just been impressed that the AI can get to 42. Now we're realizing that in a high-stakes environment, the answer is worthless without the working out.
In the age of AI, lawyers have to show their work.
They have to.
So, practically speaking, what does this actually look like inside a law firm? It sounds like a lot of paperwork. Steyn talks about an audit log.
It is paperwork, but think about how law firms already operate. They are obsessive about record keeping.
Right.
They have time records down to the 6-minute increment, matter notes, supervision protocols. Steyn argues they simply need to add an AI use record.
A paper trail for the robot.
A defensible trail of professional care. Imagine you get hauled in front of a disciplinary board because your brief cited a fake case.
Nightmare scenario.
If you stand there and just say, I don't know what happened, you're done. But if you can pull up a log and say, here is the prompt I used, here's the output it gave, here's the associate who reviewed it, and here's the specific point where we missed the error.
That's a very different conversation.
Well, totally. It changes it from negligence to procedural error.
Right.
And if you can't show that trail, then as Steyn puts it, you aren't practicing with responsible oversight. You are just hoping.
And hope is not a legal strategy.
Not at all.
I love that line. Hope is not a legal strategy. So, okay, let's get into the how. Steyn suggests a basic AI governance pack. If I'm a partner at a firm listening to this, what do I need to implement tomorrow?
It's not rocket science, but it does require discipline. Steyn breaks it down into 4 key components. First, you need a client disclosure position.
That seems tricky. Do I really want to tell my client, hey, a robot wrote this?
Well, you need to decide when you tell them. If I'm paying $800 an hour, I probably want to know if a bot did the first draft.
Yeah.
Maybe I'm okay with it if it saves me money. Maybe I'm not. But the surprise is what causes the anger.
Right. Second is a matter-by-matter risk assessment.
Not every case is suitable for AI. If you're doing a standard contract review, maybe AI is great. If you're doing a high-stakes criminal defense where someone's liberty is on the line.
Maybe you want a human looking at every single word.
Exactly. You can't just apply a blanket policy.
Yeah, then there's the data rules.
This is non-negotiable. You need rules on confidential data. You cannot just dump client secrets into a public chatbot to summarize this. That's a breach of privilege. It's a disparable offense waiting to happen.
And finally, that logging policy we mentioned. The inputs, outputs, versions, human review.
It all requires a mindset shift. Steyn suggests treating AI like a junior assistant.
A very fast, very confident, and slightly hallucination-prone junior assistant.
Exactly. You would never let a first-year associate file a brief with the Supreme Court without a partner reviewing every single line. You have to treat AI with that same level of supervision.
It is not a silent co-author.
No, it's a subordinate that needs checking.
Steyn has a quote here that I really like. Ethics is not a document. It is a habit.
And that's the hardest part, isn't it? You can have the best policy PDF in the world sitting on a server somewhere.
Yeah.
But if your lawyers are stressed and it's 2:0 a.m. and they aren't in the habit of verifying every citation,
The policy is useless.
completely, you have to train the team relentlessly.
And look, law firms aren't operating in a vacuum here. If they don't regulate themselves, someone else is going to do it for them. What's the regulatory landscape looking like?
It's uneven, but it's catching up fast. Regulators are realizing they can't just wait and see anymore.
We've seen some specific movement in the U.S. recently, haven't we?
We have. Steyn mentions that specific states are pushing for guardrails. He points to California, which is often the bellwether for tech regulation. The California Senate passed a bill in January 2026, just recently aimed specifically at regulating lawyers' use of AI.
And what does that bill actually require?
It focuses heavily on verification and disclosure. It's essentially legislating that show your work concept. You have to verify the output, and in some contexts, you're legally required to disclose that you used AI.
What about it across the pond?
The UK is active, too. The judiciary there issued guidance back in October 2025. It warned judges and lawyers about, confidentiality risks and, of course, the hallucination problem.
So the goal here isn't to ban AI in law. Steyn is not a Luddite.
No, and he's very clear on that. Blanket bans don't work. The technology is just too useful. The goal is predictable standards.
Right.
We need to know, when is disclosure required? What are the minimum records I need to keep? What level of human sign-off is non-negotiable?
Because if we don't have those standards, we run into a really ugly problem.
Yeah.
Steyn talks about a two-tier system.
This is the big societal risk. Without regulation, you could end up with a world where wealthy clients get carefully supervised, human-verified legal work. They get the bespoke suit.
And everybody else.
Everyone else gets automated guesswork. They get the hallucinations. They get the good enough probability.
That is a chilling thought. Justice shouldn't depend on whether you can afford a human to fact-check the robot.
Exactly. And transparency becomes the shield against that inequality. It ensures that even if AI is used, and it should be, to lower costs, the standard of care remains high. Clients deserve clarity no matter who or what wrote the first draft.
So, bringing this all together, the deep dive here is that the legal profession is really at a crossroads. We can use AI for speed, for access, for consistency.
Absolutely. It can be a massive force for good.
Right.
It can make justice more accessible, but credibility is fragile.
And Steyn warns about the black box. If clients start to suspect that the advice they're getting just comes from some black box with no paper trail.
Trust decays, and once trust is gone in the legal profession, you can't really get it back. If the public decides that lawyers are just prompt engineers who don't check their work, the value of the entire profession collapses.
So the final takeaway from the source is that the era of asking, is AI allowed, is over. That ship has sailed.
The new era is asking, is its use visible? Is it governable? And is it defensible? You have to be able to stand behind the work.
I want to leave our listeners with a thought here. We've talked a lot about lawyers, but this applies to so many fields. If you receive professional advice, whether it's a legal contract or maybe a medical diagnosis or a financial plan for your retirement.
Here's a question I ask myself. Would you trust it more if you knew exactly which parts were written by a machine and which human double-checked it? Or would you actually prefer the illusion that a human did it all?
Do we really want to see how the sausage is made, or do we just want it to taste good?
Transparency is great in theory, but it forces us to confront the role of machines in our lives head-on. It removes the magic and it leaves us with the process, and that can be uncomfortable.
A fascinating dilemma. We will be back next time with another deep dive into the shifting world of information. Thanks for listening.
Stay curious and verify your sources.